So my name is Deane. I'm a solicitor and I've had over 30 years experience dealing with SMEs, entrepreneurs and their investors both here and in Australia. I've been asked today to talk about the role of data protection and IP in scaling your startup. Brief overview and maybe takeaway points from today. We'll be looking at challenges when scaling up and when a business is dealing with increased volumes of data, and the 7 main principles of the Data Protection Act, in accordance with which all personal data must be processed. We'll be looking at the impact on a business of poor data management, and finally looking at being proactive when it comes to scaling up the business by developing cybersecurity awareness. The role of IP with scaling up is about identifying IP, protecting IP, and creating an IP plan and executing it. Takeaway points from today's session. I also know that it's understandable, meet the entrepreneurs, the startups, the founders. It's important at that stage that they focus on product and service launch. When it comes to scaling up, things need to get a little bit more organized, and really takeaway points from today that a scaling up business must focus its efforts on really becoming more proactive in developing cybersecurity awareness and also developing and creating an IP plan. And we'll look at the reasons for that now. So it's about expectation and reality, the differences. We have an expectation by investors, customers and the team members to multiply results quickly. Of course, that's what scaling up is all about. In reality, the growing workforce and customer base means that processing more and more data comes with responsibilities, obligations and possible liabilities. There's a high risk of being targeted by cyber criminals attempting to compromise data security. So there's going to be an increase in security breaches or attacks, hacking, viruses, distributed denial of service attacks. Cyber attacks are often cited as the top threat to businesses worldwide. Last year, Hiscox Insurers carried out a survey of about 5,500 SMEs across a number of countries and found that 60% of UK SMEs surveyed had reported a cyber attack last year, which was up from 45% in the previous year. It also reported that the average cost to a business of a cybersecurity breach had increased from around about £180,000 to £290,000. The report also reported that a lot of SMEs felt that they weren't at risk of a cyber attack, and that British firms had the lowest spend on cyber defence budgets. So with a higher risk really of data being compromised and the increased costs of a cybersecurity breach, data protection, protecting data, becomes all the more important when scaling up. A look at the Data Protection Act. This contains the main responsibilities for a business when processing personal data. The Data Protection Act of 2018 is the UK's domestic legislation that implemented GDPR into the UK. There are 7 main principles in accordance with which a business must process personal data. Principle of lawfulness, fitness and transparency. Data must be processed in a way that's lawful, fair and in a transparent manner. Purpose limitation means that data must be processed and must be the purposes for which it's processed must be specifically and explicitly stated. Data minimization means that only data which is relevant to stated purposes can be processed by a business. Accuracy means that a business must take reasonable steps to make sure that its data is accurate and up to date. Storage limitation means that data can only be stored for as long as is reasonably necessary for stated purposes. And the integrity and confidentiality obligation, or principle, is that data must be kept secure, a very important one here. And a business must take technical and organisational steps and measures to ensure that data is in fact secure. The accountability principle transcends all of the others and means that any data controller must at all times be able to demonstrate to the ICO that it has complied and is complying with all of those principles. So it's worth bearing those in mind. So a look now at the impact of poor data management on the business. Well, of course, compromised personal data. We've all read stories in the press about individuals' data that's been stolen from an organisation and it's being used, whether it's been credit card details, bank account details, in national insurance numbers, used for fraud or maybe other crimes. Not good for your employees, your customers, any other contacts whose data has been compromised. Loss of profits, business interruption and downtime. many businesses, you may have experienced this, malware, denial of service, attacks and so forth. Reports suggest that unplanned outage costs a business about £6,000 per minute on average. Under the DPA, businesses have reporting obligations now, and it's required to report a personal breach to the ICO no later than 72 hours after becoming aware of it, unless the personal data breach is unlikely to compromise data subjects. This was implemented last year, of course, in May of 2018, and my experience of dealing with clients who've had breaches and had to go through this 72-hour window of deciding whether to report or not is that it can be very stressful, time-consuming, lots of management time, and cost a lot of money. There is guidance in the DPA about what you need to take into account when deciding whether or not you need to report the breach, first of all to the ICO, and secondly to the data subjects themselves. Either of those are going to have consequences for the business, and not reporting and documenting why you don't report might also have consequences for the business, because at a later date, through that accountability principle that we just spoke about, you're going to have to demonstrate the reasons why you decided not to report. And so if you're found to be in a situation where you should have reported when you didn't, that in itself is going to lead to fines in the future. So it's a very testing time and very serious possible consequences for the business. I might mention here also that under the DPA, individuals, you and I, if we are victims of a data breach, we're able to sue the organisation that was holding our data for damages under the DPA, damages for distress, and also for any financial consequences that it has caused us. The damages that are being awarded for distress by the courts would generally be around the £1,000 mark, which is quite modest. But we do have now lawyers and legal claims companies that are trying to bring together groups of people and handle group litigation actions on behalf of people who are the subject of whatever it might be, whether it's financial mis-selling or otherwise. And this might be an area of growth here. So it could well mean that a business might face claims which individually are low, but when they're put together as a group litigation could be very high, remains to be seen. Regulatory fines, these were the subject of lots of press coverage last year in the run-up to the implementation of GDPR. The lower end of the scale, 2% of global turnover, 10 million euros, would be for things like failure to integrate policies, demonstrating implementation of data protection and the principles we just looked at, failure to cooperate with the regulator, failure to inform data subjects of compromised data, and keeping adequate records of processing. The higher end of the scale is reserved for more serious infringements, such as not following basic data protection principles and refusing to comply with demands and requests from a regulator. So there's no way out. Theft, compromise of intellectual property. Hackers might access and steal customer lists, confidential materials and trade secrets. I'm seeing more of this with clients in the last year, certainly. We're having clients come saying that they've been hacked. It might be disgruntled ex-employees. Sometimes it's been that they suspect competitors. And it's very difficult, it's very time consuming. Sometimes we have to get to the bottom of who's got the data because it's not always that clear. It might mean that we've got to go to court to try and get orders, forcing somebody to make disclosure of what they've got, or allowing us to go into premises and to take copies or images of computer files. It's not always easy. Breaches of contract. So the impact of poor data management could well mean that if there is a breach, then that's going to place your business in breach of contractual obligations of confidentiality for data to your customers, your clients. It might also mean a breach of contractual obligation to keep that data secure. What does that mean? Well, often that's going to mean that you've got an unhappy client whose data you promised to keep secure and confidential. They may have a claim for damages against you because they may suffer consequences. They may have decided to report it to the ICO. They may say that all of that cost is down to you, and so they're going to claim that from you as damages for breach of contract. They might also say that that's the end of it. That's a serious breach. It's material breach under our contract, and so we're terminating the contract without notice with the innocent party, and we can do that. Damages to reputation. It's widely reported that most data breaches and cyber attacks could have been prevented. And this can often be something which is very damaging to reputation. And trying to rebuild commercial trust amongst stakeholders after a breach is one of the most difficult tasks to achieve for any business, regardless of revenue. So cybersecurity awareness then, taking something away from this. As I mentioned, many startups, they've not allocated budget to cybersecurity. It's all about launching the product or the service. When scaling up, the single most effective way to protect the business from a data breach is security awareness training. That in itself is going to make the business aware of what it needs to do, what it needs to spend, what its risks are, and what it should do about it. It's an ongoing thing. Spend money on training the team to avoid doing things, simple things really, that leave a business vulnerable to cyber attacks with handheld devices, passwords and so forth. Really, when scaling up, it's about changing the mindset of the business. A business now needs to think about, well, these things happen, and yes, we're a startup, we're risking it, we just want to get something to market and get something that's doable. But now we need to realize that breaches, cybersecurity breaches, the regulatory fines and possible damages, it's not just about the big organizations, it also happens to SMEs. If we're going to believe that as a small business we're not going to get targeted, we're not at risk, then we're really not going to spend any money on cybersecurity training, on cybersecurity itself, and that's going to mean that the business is more vulnerable to attack. And what that means then is that scaling up itself is at risk. So, as I say, taking anything away, it is really about security awareness training. So moving on to intellectual property and scaling up. The IP is often intangible. It represents an important financial and legal asset for companies, especially those that are scaling up. Software technology companies depend on IP perhaps more than any other type of business. I often say to clients, what is your intellectual property? We all hear about it, and lots of people have different definitions of what it is. But sometimes, it's just something there. I know it's important to the business. I don't really know what it is, So sometimes we might sit down and say, well, let's think about what it is. And they say, tell me what it is. I say, well, here's a definition I quite like. It's the original concepts and ideas that are thought of and developed by the business, either by its employees or by its workers and contractors and advisors who have been contracted to actually develop it. And then that becomes the assets of the business. And that's your IP. It is intangible very often. Most people might say, okay, yeah, logos, business names, written content, photos, graphics, work processes, pricing lists and databases, inventions, software code, products. Sometimes it's good to sit down and write a list of everything you think might comprise what you believe is your IP, and then go to somebody who might be able to help you work out whether there is more. Once you've worked out what the IP is, it's about protecting IP. IP is protectable, and you'll find that your potential investors and your collaborators, whether they're distributors, resellers or otherwise, they're going to want to make sure that there isn't any danger of somebody over here saying, hang on a minute, I've got rights to that IP, I'm going to stop you from using it, and compromising the business model and viability of it. Copyright, of course, protects written and creative ideas, which are pulled out, written, if you like, manifest themselves through writings or drawings, and also protects computer code. Trademark registration is going to protect the name and brand of a business. Patent registration and protection is given to product and process inventions. Trade secrets protection, that's for working processes developed and owned by a business and for which the business has actually applied some degree of secrecy and can demonstrate that it has done so as well. There's also design right protection for designs. There's unregistered design rights and registered design rights. And any of these may be relevant to different parts of your IP. So scaling up at the startup stage, like I say, the founders they're less likely to recognize the extent of potential IP assets or appreciate their importance and the need for protection. And that's due to lack of awareness, but more likely busy moving forward with product or service launch. A not uncommon story, in fact quite common, is that we might as well leave that protection of IP until it's time to sell the business. Get away with it. Investors weren't too insistent that we have a thorough due diligence on our IP when the investment came in. But when we come to sale, the due diligence in the sale process may then reveal uncertainty about full ownership of IP. There could have been contractors, contributors that haven't actually assigned their IP into the business and may therefore be out there presenting a risk, however great or small, that needs to be factored into the purchase price. And that could well mean that when you get to due diligence process on an exit, that you find that the price that was agreed on the assumptions back at the heads of term stage becomes lower now because risks have been identified. And those risks would also be taken over into the warranties and indemnities that the sellers of the business are required to give in the share purchase agreement, so that if any claims are made in the future in relation to IP, which impacts on the value of the business, that then would represent a claim against the sellers of the business. It also means that there can be lots of scrambling around at the last minute, the costs and the stress of that, trying to get agreements in place with contributors, registrations in place in whatever markets you might be trading in. Scaling up, it really is time for the business to become proactive by taking steps, first of all, to help avoid future problems with IP assets, and then to attract more serious investment. So, what about creating an IP plan and executing it, becoming more trustworthy, more attractive to investors? Well, the strong IP portfolio might identify, as I mentioned, all those assets, IP assets, and how they're protected. It's an ongoing thing. Have this in one place. Review this with somebody responsible and with external advisors. It's a good management risk tool, and it allows you to go and be able to confidently say to somebody, if you're licensing your IP, these are our rights, these are what we say about those rights, and these are any licenses we've got from third parties or permissions if we need them in order to actually use these rights. A well put together presentation of IP for fundraising purposes is great. Investors will like it. The IP plan also will enable informed decisions to be made about taking action against infringers. If you go to lawyers and you say somebody's copying me or I don't like what they're doing, they'll say, well, how do we establish first of all that you've got a cause of action and the merits of your claim? They're going to want to look at what you've got that evidences your IP and analyse what your IP is. Licensing of IP, well, it can increase the revenue of the business, and licensing of IP, like I mentioned, is made easier when you can demonstrate that you've registered and protected it and you've identified it. Protecting the brand, consider geographical locations. It's also wise for business, if it's looking at expanding into other markets, to be able to scale quickly and extensively by protecting the brand, the innovation and the design with IP rights registered in the major countries. And then that means that nobody else is going to be cyber squatting, that you might have to deal with trying to negotiate with somebody who's got in there because they've seen that you've raised your profile in other markets. Opportunists or people that just happen to have got in there before you. So again, an IP plan would look at how you might develop registrations in overseas territories as well. Potential stakeholders, as I mentioned earlier, investors, resellers, distributors, agents, they're all going to be looking to for the security of registered IP rights and protected IP rights when assessing how effectively a business might deal with third-party infringers. If a business is seeking to chase up and take action against third-party infringers, it's got to ensure that it's done some form of legal protection and registration, and that's at the back of its IP. And the inability to deal with infringers can, of course, lead to a competitor taking away your market share. So taking away from this, really it's about gathering together what you believe is your IP and how it is and should be protected, and who might have created that IP, and making sure that you've got documents in place that demonstrate that IP has been properly assigned to the business and that you have full ownership of it. Final word from the Intellectual Property Office, which is a good source of information if ever you want to check out the website, especially around tech businesses. Intangible assets, in which much intellectual property often sits, is hugely valuable. By protecting this, you're making yourself more valuable and attractive to the wider market and mitigating risk at the same time. So, there we go.
Brilliant. Thank you, John.
Excellent.